Just like drafting a plaint for filing a civil suit, drafting a written statement is also important. And this video is about that only. Hello friends, welcome to another episode of Legal Inspiration. I am Advocate Nahush Khubalkar, a practicing advocate. I practice before Nagpur bench of Bombay High Court. This video is for my young advocate friends who want to learn the skill of drafting of pleadings. See, I have already made numerous videos on the skill of fundamentals of drafting of pleadings, and these videos are available in the form of playlist on this channel. The entire playlist is actually a mini course for young aspiring advocates who want to learn the basics of drafting. So, if the young lawyers watch all those videos in the entire video series one by one, they will get to know the fundamentals of drafting skill. This video on how to draft a written statement, that means a reply to a plaint, is an addition to that collection. Friends, recently while studying in the library, I happened to read a latest judgment of the Supreme Court of India, in which the Supreme Court has masterfully guided the legal fraternity on how to draft a written statement. That judgment is a valuable jewel for the legal community, and I couldn't resist the urge to share the teachings in that judgment with my young lawyer friends here on this channel, and therefore I am making this video. So my dear young lawyer friends, the first thing to understand is that the very fact that the Supreme Court of India, the topmost court of this country, found it necessary to guide the legal fraternity about how to draft a written statement and replies, that speaks loudly of the quality of drafting of written statements noticed by the Supreme Court. And that is why I am making this video, to explain all that is said by the Supreme Court, so that it reaches the maximum number of lawyer friends, both young lawyers and not so young lawyers, but who want to learn this art. So, while giving guidance in that judgment, the Supreme Court has thrown light on common errors in drafting of written statements and offered best practices. And what else can be the best opportunity than this for lawyers to learn drafting directly from the Supreme Court of India? Thanks to the Honorable Supreme Court of India. Well, the judgment is reported, and that is reported at this citation: 2024, Volume 4, Maharashtra Law Journal, SC, page 41, in the case of Thangam versus Navamani Anmal. I express my sincere thanks to Maharashtra Law Journal, a reputable law journal reporting the cases of various courts, especially Bombay High Court and the Supreme Court of India, in its monthly publication. You can read the judgment later any time, dear friends. And I am making a PDF copy of that judgment available to you for free download. But to correctly understand what is explained by the Supreme Court, please watch this video completely and with full attention. Because in addition to what the Honorable Supreme Court said in the judgment and taught in the judgment, I will be adding for you some do's and don'ts while drafting a written statement. And I will also be sharing a few drafting examples I can think of. So are you ready? Okay, now let's get into the essential details of the skill of drafting a written statement. First things first, what is a written statement? Now I know this is a very basic thing to know, but let us clear our ideas. To tell you simply, a written statement is a written reply to a plaint in a civil suit. A written statement is a pleading in written form filed by the defendant in a civil suit in response to a plaint which is filed by the plaintiff. And mind well, I am saying it's a response. The response may be either to defend himself by resisting the plaint and a civil suit, or it could be to admit the plaintiff's claim, or it could be a mix of both. In most situations, it is for resisting the claim or opposing the claim in the plaint. That's in short about written statements. So having understood that, now coming to the judgment of the Supreme Court, it's important to note the concerns raised by the Supreme Court regarding improper drafting of written statements. Of course, the Supreme Court is speaking about drafting by lawyers. That concern is about the lack of specific paragraph-wise replies in written statement and counter affidavits. So this defect, that is the defect of absence of specific paragraph-wise replies in the written statement, not only hampers the efficiency of legal proceedings, but also makes it challenging for the court to understand the key arguments and counter-arguments which are presented by the parties. Therefore, when drafting a written statement, meticulous attention to detail is very important, and that is to ensure that each point is addressed clearly and concisely. And by providing paragraph-wise responses, not only do you streamline the court's understanding of the case, but you also demonstrate your professionalism and your commitment to presenting your arguments in a structured and coherent manner. Ultimately, prioritizing clarity and precision in your written statements, that certainly benefits the court, judges, but it also enhances your credibility as a legal professional. Imagine this hypothetical situation. The plaintiff meticulously pleads his case in 10 succinct paragraphs, each detailing specific points of contention. But when the defendant submits his written statement, it meanders. That means he goes zigzag through 15 unrelated paragraphs without directly addressing the plaintiff's allegations. So this lack of specific replies creates a disorganized and inefficient process, because the court is left struggling to decode the connection between the plaintiff's claims and the defendant's responses. And this absence of clarity prolongs the legal proceedings, and it also leads unnecessarily to confusion and frustration for all the parties involved, including the judge, the lawyers, and the clients. And this stresses the importance of providing precise and focused responses in written statements. And this is to ensure a very smooth and effective resolution of legal matter at hand by the court. But then, where are all the guidelines given? You might ask. They are in CPC, the Code of Civil Procedure. So please read and study the concrete guidelines laid down in CPC. Order 8, Rules 3 and 5 of the Code of Civil Procedure, CPC, are about the manner in which the allegations in the plaint must be dealt with in a written statement. What are these rules or guidelines all about? These rules require that the defendants should give specific admissions or denials for each individual allegation presented in the plaintiff's plaint. Simply offering a broad or evasive denial is not enough. It falls short of complying with the procedural requirements given there in the rules. See, sometimes a defendant might admit to facts in the plaint by simply not addressing them, by simply being silent about them. Yes, it's a rule that silence amounts to admission of a fact, and maintaining silence by the defendant may amount to admission of the plaintiff's pleading in a plaint. And in such cases, one may say that the court should proceed on the basis of the facts pleaded by the plaintiff and admitted by the defendant in this manner. In this manner means by maintaining silence. But whether to do so or not is the discretion of the court. And instead of moving forward based on such vague admission, the court can ask the plaintiff to prove those facts with evidence despite defendant's silence. The proviso to Order 8, Rule 5 gives the court the authority to demand evidence from the plaintiff for proving any facts that have been admitted in this manner by maintaining silence, but not clearly acknowledged by the defendant. And this is where the importance of meticulous and transparent responses of the defendants in the written statements come from. It stresses the obligation of the defendants to deal with the content of the plaintiff's claims in a plaint in a precise and thorough manner. And by adhering to these rules, discipline, the parties in legal proceedings demonstrate their commitment to ensuring accountability, clarity, and integrity in the litigation process. Please understand the implications of these legal requirements. They are very important in guiding the drafting of your written statement. In practical terms, this means that your response in the written statement should be meticulously structured to deal with each specific paragraph of the plaintiff's plaint. This approach ensures that your written statement is thorough, coherent, and responsive to the issues raised by the plaintiff. And that was what can be gathered from the judgment of the Supreme Court. So, on the basis of that, now let me share some do's and don'ts to improve the clarity and effectiveness of your written statement. Okay, so here are the do's. Do provide paragraph-wise replies. It's really necessary to approach the drafting of your written statement with precision and thoroughness. To do so, focus on providing paragraph-wise replies to the claims or allegations made in the plaint of the plaintiff. Deal with each paragraph specifically. And this way, you achieve clarity in your responses. You also establish a transparent and organized framework for dealing with the case at hand. And this practice helps in identifying the points of agreement and the points of disagreement between the parties. And this facilitates a more structured and effective resolution of the legal dispute. Let me give you an example. Suppose the plaintiff's allegation in paragraph number 4 of the plaint is, the plaintiff states that on 1st January 2025, the defendant failed to deliver the goods as agreed upon in the contract dated 15 December 2024. Suppose this is the allegation in the plaint. So what could be the defendant's incorrect way of reply? It could be something like this. The defendant denies all the allegations made by the plaintiff and submits that there was no breach of contract. And what could be the defendant's correct way of reply? It could be something like this. The defendant specifically denies the allegations in paragraph number 4 of the plaint. The defendant states that the goods were in fact delivered on 2nd January 2025 due to mutual agreement between both the parties to extend the delivery date by 1 day. So this clarifies that the defendant's case is that, firstly, it is true that the defendant failed to deliver the goods on 1st January 2025. Secondly, that there was a modified mutual agreement between the parties to extend the date of delivery by 1 day. And thirdly, that as per the mutually extended date of delivery, the defendant actually delivered the goods on 2nd January 2025. Clear? Well, the next do is be specific in admissions and denials. See, when formulating your responses in the written statement, it's really very important to be specific. The responses could be in both admissions and denials. If you choose to deny an allegation, it is necessary for you to do so with precision and clarity. Broad and generalized denials, that they can potentially be misconstrued as admissions, and they may lead to misunderstandings and complicating the legal proceedings. So, by articulating your denials in a specific and unambiguous manner, you convey a clear and confident stance on the issues raised in the plaintiff's plaint, and then you can enhance the coherence and strength of your defense. Let me give you an example. Suppose if the plaintiff's allegation is that the plaintiff states that the defendant was aware of the faulty product and still proceeded to sell it to the plaintiff. If this is the pleading in the plaint, now what could be the defendant's incorrect way of reply? It could be something like this. The defendant denies the allegations made by the plaintiff. Simple. That's the most incorrect way of replying to a pleading. And what could be the defendant's correct way of reply? It could be this. The defendant specifically denies the allegations in paragraph number 6 of the plaint that the defendant was aware of any defect in the product. The defendant asserts that the product was tested and found to be in good working condition prior to the sale. Now that is a precise way of dealing with the plaintiff's pleadings. These are just some examples, and there could be a better way, of course, of dealing with all these. But I am sharing with you what is striking me while talking to you. But these could be good guides for you to understand what I mean. And it's for the defendant to lead evidence and prove during the stage of evidence as to where and when and in what manner he tested the product and found it to be in good working condition prior to the sale. But the evidence stage comes later. For now, the defendant has to properly deal with the pleadings contained in the plaint. That's the thing that you have to understand. Now coming to the next do. Do state preliminary objections very clearly. Now in situations where you intend to raise preliminary objections to the plaintiff's plaint, it's very important to state these preliminary objections clearly and concisely in your written statement. List them in separate and numbered paragraphs, and this highlights their importance and that streamlines the communication of your legal grounds of objection. And this structured approach, it just not only enables the plaintiff to address these preliminary objections of the defendant effectively, but also, and most importantly, it helps the court in identifying the key issues at hand. So, by presenting your preliminary objections in a very clear and organized manner, you contribute to a more efficient and focused legal process. And at the same time, you ensure that your objections are duly noted and considered by the court. Okay, let's see this example. The defendant's improper way of raising a preliminary objection. How would the defendant do it incorrectly? The defendant says, the defendant objects to the plaintiff's claim on ground that it is frivolous and lacks merit. This is the incorrect way of raising a preliminary objection by the defendant. And what could be the defendant's proper way of raising that preliminary objection? It could be something like this. The defendant raises a preliminary objection that the plaintiff's suit is barred by limitation under Section 3 of the Limitation Act 1963 because the cause of action arose on 1st January 2020 and the suit was filed on 15th February 2024. The defendant further objects to the jurisdiction of this honorable court for the reason that the contract was executed in Mumbai and therefore the suit should be filed in the courts of Mumbai. So friends, those were the do's. I hope these things are becoming clear to you as you go on watching this video, hearing these examples. And now here are some don'ts. First don't, avoid general denials. When crafting your written statement, do not resort to general denials without specificity. Declaring a blanket denial of all the allegations without providing detailed and specific responses that can have adverse consequences. And such generalized denials may be interpreted by the court as admissions, and they may potentially undermine your defense and weaken your position in the legal proceedings. So by staying away from your vague denials and instead of that addressing each allegation distinctly, you enhance the clarity and credibility of your defense, while at the same time safeguarding against a misinterpretation that could damage your case. Let's see an example. Now suppose if the plaintiff's allegation is that the plaintiff states that the defendant failed to pay the agreed amount of rupees 1 lakh on 1st March 2024 as per the contract terms. Now what could be the defendant's improper way of reply? The defendant denies the allegation regarding non-payment of amount in the plaint. Wrong way. Now what could be the defendant's proper way of reply? It could be something like this. The defendant specifically denies the allegation in paragraph number 5 of the plaint that the defendant failed to pay the agreed amount of rupees 1 lakh on 1st March 2024 as per the contract terms. The defendant asserts that the payment of rupees 1 lakh was made on 28th February 2024 via bank transfer, and the delay, if any, was due to technical issue on the plaintiff's part. Clear? Next, don't mix issues. Always maintain a disciplined and organized approach in structuring your written statement, and refrain from mixing the allegations from different paragraphs. Keep your responses segregated and aligned with the corresponding allegations in the plaint. And this helps prevent confusion and ambiguity in the presentation of your defense. And such a mixture of unrelated issues from different parts of the plaintiff's plaint that muddles the central arguments. It also dilutes the coherence and strength of your response, my dear friends. So always stick to a clear and systematic arrangement of your replies. And that way, you enhance the effectiveness and impact of your defense while facilitating a more streamlined and coherent legal process. Example: wrong pleading in defendant's written statement. The defendant says, the defendant denies paragraph number 2 of the plaint regarding the delivery date and also objects to the plaintiff's claim for damages in paragraph number 8. Wrong. The correct pleading of the defendant could be like this: the defendant's reply to paragraph number 2. The defendant specifically denies the allegation in paragraph number 2 that the delivery was delayed. The delivery was made on the agreed date on 1 January 2025. Next, the defendant's reply to paragraph number 8. The defendant objects to the claim for damages in paragraph number 8 for the reason that no actual loss was incurred by the plaintiff as a result of the alleged delay in delivery. Next, don't skip details. In drafting your written statement, ignoring the necessity of addressing each admitted or denied fact with precision and thoroughness can be damaging. Mind well, precision and thoroughness. And failing to get into the specifics of each assertion can result in court making assumptions or drawing inferences that may not align with your intended stance, your intended defense. So, by neglecting to provide detailed responses, you risk leaving gaps that could be exploited to the detriment of your case. And therefore ensure that every fact you address is tackled directly and comprehensively. This is a safeguard against misinterpretations, and this improves the clarity and persuasiveness of your defense. Again, let's see an example. I hope you are enjoying this video and it's really adding to your knowledge and to your value. Now, suppose if the plaintiff's allegation is that the plaintiff alleges that the defendant did not provide the required quality certification with the goods. Now, the defendant's incorrect way of reply could be something like this: the defendant denies the allegations regarding the quality certification. Simple, but not right. So what could be the defendant's correct way of reply? It could be something like this: the defendant specifically denies the allegation in paragraph number 7 of the plaint that the required quality certification was not provided. The defendant then states and asserts that the certification was included with the delivery on 1st January 2025, and a signed acknowledgement from the plaintiff's representative was obtained at that time. So those were the do's and don'ts which I shared with you on the basis of the principles deduced by the Supreme Court, as well as those found in the Code of Civil Procedure. Now moving ahead, let us understand the references given by the Supreme Court in that judgment of other judgments of the Supreme Court itself. Friends, the importance of providing specific and detailed responses to each fact in the plaint has been reinforced by the Supreme Court through references to some leading cases. In the landmark case of Bodat and Company, Bombay versus East India Trading Company, reported at AIR 1964 Supreme Court, page 538, the Supreme Court elucidated the crucial requirement for the defendants to address each fact in the plaintiff's plaint directly and without evasion. It was expressly emphasized that evasive responses or general denials do not fulfill the procedural obligations and are tantamount to, that means are like, admitting the facts in question. And this traces the principle that a failure to engage with the specific allegations in a plaint in a thorough and unambiguous manner can result in those facts being sometimes taken to be admitted by default by the court, absolving the plaintiff of providing further evidence to substantiate them or to prove them. So, by highlighting the precedents set in such cases, the Supreme Court stressed the importance of diligent and precise responses in written statements to uphold the integrity and fairness of the judicial process. The legal principle that facts not specifically admitted or denied in a written statement are deemed as admitted was laid down in the case of Lohia Properties Limited versus Atmaram Kumar, 1993, volume 4, SCC, page 6. In this landmark judgment, the court reaffirmed the critical importance of providing explicit and precise responses to each factual assertion that is made in the plaint by the plaintiff. So that judgment clarified that any fact left unaddressed or unambiguously acknowledged in the written statement that carries the quality of being accepted as true, and that may shift the burden of proof onto the defendant himself. Please know these things. So this judicial interpretation, it serves as a stark reminder of the importance of accuracy, specificity, and transparency in the drafting of pleadings. So by stressing the repercussions of failing to explicitly rebut or admit allegations, the Supreme Court emphasized the necessity of diligence and meticulousness in preparing the written statements to ensure a fair and just adjudication of legal dispute. Therefore, my dear friends, always stick to the principle of addressing each fact distinctly in pleadings. This is not merely a formal requirement, but it's a fundamental aspect of upholding the integrity and efficacy of the legal process. So from all that you heard and understood, what is the final key? It is this: the key to preparing effective written statements lies in the pursuit of clarity and precision. Approach the drafting process with a commitment to addressing each allegation in the plaintiff's plaint directly and unequivocally. Avoid general denials and opt for specific and detailed responses. And this way, you improve the transparency and the acceptability of your defense. In addition, present any preliminary objections you want to raise very clearly. And this ensures that your legal grounds for objection are readily understood and considered. So stick to these fundamental principles. They ensure compliance with legal mandates and also significantly contribute to the efficacy and impact of your presentation before the court. And when you always follow these essential guidelines, you not only fulfill your procedural obligations, but also elevate the persuasiveness and coherence of your case. And this ultimately increases your chances of achieving a favorable outcome in the case. Dear viewers, I sincerely appreciate your viewership and engagement with my videos. Your support means very much to me. Your active participation in the comments is invaluable to me, and it fuels my motivation to create more content that resonates with your interests and needs. Thank you once again for your time and attention. I look forward to connecting with you in our upcoming videos. Stay tuned for more insightful discussions and engaging content on legal matters. Until next time, take care and have a wonderful day.